Today is a very exciting time in our life history. We are having one of the pillar of the MVA, the father of MVA, the only author that I know in South Africa who write on MVA. His name is His Excellency Professor H.P. Klopper. Please, Prof, welcome and introduce yourself and tell us your name and your background. Thanks, Prof.
Thank you. I've been at this game I've been an attorney for more than 40 years, 47 years to be exact. So I switched from being an attorney and I became an academic in 1982. And since then I spent my time first at the Technikon, and then after that at the University of Pretoria, and I'm now emeritus professor. I retired in 2011, but I'm still actively pursuing my interest in third-party compensation. In the meantime, I have written a textbook on damages. I also did a electronic quantum program with LexisNexis, which came on stream last year. And I've been engaged in working against RABs with my colleagues at APRAV, and I'm glad to say that we succeeded with that action in having RABs removed from the parliamentary schedule in September of last year. So my interest and my whole life has been revolving around third-party claims or personal injury claims arising from motor collisions. I became a lawyer because of the fact that I was a third party. I was injured in a motor vehicle crash in so many years ago, in 1960, and I went with the attorney to the council's chambers, and I saw all the books and all the paraphernalia of an advocate, and then I decided I would like to become an advocate, and my resolve was strengthened when at the end of the matter I received nothing, no compensation out of that claim. It all went into legal fees and to paying my grandparents who were also injured in the accident, to paying their costs. So I've seen it from all sides. I've been a victim. I've been a attorney who deals with third party claims, and I've taught third party claims. And my interest is still third party claims, even though I've retired and been retired for now close on 10 years. I'm still actively pursuing my interest as far as that is concerned.
This is very, very exciting. What moved me is that, Prof, the reason why he became a lawyer, he was engaged with an attorney to claim for the claim from the RAF, and it looks like, Prof, you didn't receive any cent.
Yeah,
so all the money went to the legal costs.
At that time, it was still it was a compulsory insurance, and it was an insurance company, but the principles still remain the same. It didn't change from then up to now. It's still the same game. The only difference was that the claim was financed by insurance premiums. It's now financed by fuel levies. So you pay R2.07 of every litre of fuel that you put in your vehicle, and that goes towards funding the RAF to the extent of about 43 billion rand a year.
Sure. So it's a lot of money. That was the question that I was going to ask the Prof. Where did the RAF get its money from? Prof said it's from the levy.
The fuel levy.
Yes. Yeah. So each and every motor vehicle that is running on petrol, they are contributing to and also the diesel.
Interesting fact is that if you have a motor vehicle and you travel 10,000 kilometers per annum, and you get a fuel consumption of 7 kilometers per litre, it costs the average motorist about 432 rand a month to have cover.
Yeah, that's
quite. And for a taxi owner, it comes to about six to 1,000 and 600 to 1,000 rand per month for that. So you can understand, the more crashes there are, the more expensive it gets.
It's so exciting. What I want Prof to do, I want Prof to not to speak more technical, but to speak to ordinary South African on the street who want to claim for the RAF. I wanted to check with Prof who qualified to claim from the RAF. Prof.
Well, in order to claim from the Road Accident Fund, you need to be a person who was bodily injured, or you suffered loss as a result of the death of a person who owed you a duty to maintain you, to support you. So those are the two prerequisites. And then secondly, the loss must be occasioned by the negligence of the driver, the other driver. So if you cause your claim by your own negligence, you do not have a claim. You have to pay your own damages. But if you should have a situation where the other driver was negligent, you can claim your damages, excluding, of course, things like patrimonial loss, stuff that you own. Like let's take an example. You break your false teeth or your glasses in a collision. Then under those circumstances, you can't claim that from the Road Accident Fund. You can claim that from the negligent driver. Excluded from these claims that you have against the Road Accident Fund are claims for emotional shock if you are not a victim in the crash. So if you have a close relative who dies and they inform you of the person's death and it causes a psychiatric injury, then in those circumstances you must claim from the negligent driver. If you were in the crash itself and you see one of your close relatives dying in the crash that you were involved in, then in those circumstances you will be able to claim those psychiatric injuries, the consequence of those. You can claim that from the Road Accident Fund. And there are also other exclusionary circumstances. So if you do not comply with the provisions of the RAF, for instance, the RAF Act provides that you need to lodge an affidavit with the Road Accident Fund within a reasonable time of submitting your claim, and you fail to do so, then your claim can be excluded. You lose your claim against Road Accident Fund and also against the wrongdoing driver. There are a few other technical exclusions, but we won't go into those at this stage. But one needs to be aware of the fact that there are exclusions.
Okay, no, thank you very, very much, Prof. But also wanted to ask, Prof, I know most of our viewers, including our clients, they always wanted to ask, why should only be attending, launching the claim on my behalf? Can I do it personally to the RAF?
There's nothing preventing a person to do it personally, but that is fraught with all sorts of dangers, because the area of third-party compensation is rather complicated. It's not a code where you can, like a computer, press a few buttons and then your claim is complete. And the danger of that is either you're going to come short that you cannot prove the fact that the other driver was negligent, but mostly that even if you can prove that he's negligent, you are going to be hard pressed to be able to show the amount that the RAF has to pay for the injuries or for the support that you've lost. And for that reason, you need to approach a qualified expert. And attorneys generally have got the knowledge, not all of them though, but they have the knowledge to be able to assist you in lodging the claim and bringing it to finality. There's another advantage of doing it through an attorney, is that every attorney that practices has to be in possession of a Fidelity Fund certificate. So if the attorney should walk away with your money after claiming from the RAF, the Fidelity Guarantee Fund, the Legal Practice Fidelity Guarantee Fund, will reimburse you for the money that you lost. So you've got a sort of an insurance policy against dishonesty of the person that is dealing with your claim against the Road Accident Fund, which is not the case where, for instance, the Road Accident Fund should do your claim directly. you can go to the Road Accident Fund and they can assist you to lodge a claim. But you can understand when you do that, the Road Accident Fund has got a interest in that claim, and it is dangerous to do so because, in all probability, the offer that you're going to make is going to favour them rather than you, because they've got no legal duty to look after your interests, and they've got their own interests to look after. Even more so because the Road Accident Fund is short of money. So under those circumstances, I would not advise anybody to lodge a claim with the Road Accident Fund unless it's, for instance, for loss of for medical expenses or some simple thing like um,
Funeral cost maybe.
funeral costs. When it's just a question of recovering money that was paid out, then one can try and attempt to do it yourself. But there's much more to the lodging of the claim than meets the eye.
Wow, that's very powerful. Prof have already answered most of the questions that I wanted to ask him. Remember, he was my lecturer at University of Pretoria many years ago. I also have worked for the RAF for more than 10 years. So, Prof, I've got knowledge of the RAF as well. So some of our clients, they keep on asking a very simple question. They said, I'm an unemployed and I was injured. How can I claim the future loss of income if I cannot even prove it? Can they claim as well?
Well, in order to claim damages, you must have suffered damages. That is the rule. So if you haven't suffered damages, you can't claim. So in order to claim loss of income, you must show that you did earn an income, and that because of your injuries, you're now unable to earn the income in the future. Now, what's happened in the meantime, in 2008, the government sought to reduce its liability, and it reduced the amounts that people can recover from the Road Accident Fund in preparation to the implementation of a new system which would have changed the whole background and the way that the claims are dealt with. The government took away the right of such people, such as you mentioned now, to claim general damages, that is pain and suffering and loss of amenities and that kind of losses, unless that person suffered a serious injury. And the bar was set so high for serious injury that it denuded most of the claimants of their right to claim compensation for pain and suffering. Added to that, the income loss was capped at 16,000 Rand. Currently, it's about 25,000 Rand a month, and it is an arbitrary cap. It was approved of by the Constitutional Court, but I gained the impression that the main reason for that is that the court thought, well, they're going to introduce a new system, so as a temporary measure, I'm going to allow these curtailment of the rights of third-party claimants. As things now stand, those type of restrictions are, in my view, uncalled for. It should be reintroduced because if you consider that a great proportion of claimants are injured while they are pedestrians, up to 60% of them, and the injuries that people generally sustained are lower limb injuries, it's the lower leg or the upper leg, and only about 5% of the claims exceed 500,000. So that the majority of the claims are for bodily injuries of a less serious nature, and because it's of less serious nature, you do not qualify for general damage compensation. Now, from my experience, I know that the money that people got for pain and suffering were usually used or employed to improve their lives. They would improve their house, for instance. They would acquire transport, for instance. Now, if you've got a claim and you're not seriously injured, then you cannot get that kind of compensation. And despite the fact that they've limited the compensation, the Road Accident Fund still spends 25% of their income in compensating seriously injured persons for their pain and suffering. So that you can claim from the Road Accident Fund if it is got to do with bodily injury or with the death of your breadwinner. And you can claim what you've lost in monetary terms and also in non-monetary terms, provided that you're seriously injured.
Wow, this is very powerful. I just want to take a few minutes break so that I can give my colleague as well a moment to ask some few questions. Thank you very, very much, Prof. I'll come back again. You can just a few minutes break so that I can also give Prof an opportunity to take two breaths to have a coffee. Thank you very much for joining us.